Why, hello, fellow Patriots, and welcome to the Patriot Dad channel, where we can talk about current events and modern issues, all while keeping it as real as possible. Today, I wanted to talk to you about the U.S. Bill of Rights. This is a continuation of our series about the U.S. Constitution. The Bill of Rights encompasses the first 10 amendments for the U.S. Constitution. Today, though, we're going to cover amendments 1 through 5. And in September of 1789, during the first Congress, 12 amendments were proposed. However, 10 of the original 12 were finally ratified on December 15th of 1791, thereby creating the U.S. Bill of Rights as we know it today, setting in stone amendments 1 through 10, which was actually Articles 3 through 12 of the original proposals. So for the First Amendment, we have that Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So the First Amendment encompasses a whole bunch of things. Whenever you hear people talking about the First Amendment, they're pretty much almost always talking about the freedom of speech. This freedom, however, is only one of the parts. There's several protections here in the First Amendment: to express ideas through speech and the press, to assemble or gather with a group to protest or for other reasons, and to ask the government to fix problems that they've identified. It also protects the right to religious beliefs and practices, and it prevents the government from creating or favoring a religion. Not only of creating a religion, but preventing the marriage of religion and the government, as seen prior in things like the Church of England. So the government would not say which or how a religion was to be practiced in the United States, just that it would protect your ability to do so. So that's very important. Then we move on to the Second Amendment, one that's very popular among people that I know, including myself. Even though my Second Amendment rights were taken away from me here not that long ago, thankfully I was able to get them restored. But the Second Amendment states that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. It's amazing how many times, though, that we've allowed those rights to be infringed in the name of safety or security or some other nonsense. Or somebody goes in front of a magistrate and says some things that aren't necessarily true, and you can't defend yourself, and then they get taken away from you, and that's neither here nor there. But the Second Amendment protects the right to keep and bear arms, which is critically important. Not only that, but people always argue that, oh, a well-regulated militia, that must mean we need to control them. However, if you look up source material about what well-regulated meant in the 18th century, you see here that well-regulated in the 18th century tended to be something like well-organized, well-armed, well-disciplined. It didn't mean regulation in the sense of how we use it now. Say in that it's not about the regulatory state. There's been nuance there. It means the militia was in an effective shape to fight. So in order for the militia to be in a condition to fight, it meant that the people's right to keep and bear arms shouldn't be infringed, because if you did, how were you supposed to grab your arms when you're conscripted and go to war to fight on behalf of your country if you were not allowed to have weapons of your own? You gotta remember, back then, central armories and huge standing armies weren't really a thing in the US yet. It was mostly by conscript. So everybody had to have guns, and you needed to have guns in order to be well regulated. For the Third Amendment, it says that no soldier shall, in the time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So the Third Amendment prevents the government from forcing homeowners to allow soldiers to use their homes as effectively a barracks. Before the Revolutionary War, laws gave British soldiers the right to take over private homes. That seems kind of messed up, and I don't think our founding fathers liked it, because they specifically laid out in the Third Amendment that in the US, we weren't going to do that. We're better than that. So I'm a big fan. Fourth Amendment, the right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So you see here, clearly laid out, the government cannot just search your property and take things from you. It must have probable cause. It must be supported by oath or affirmation of the officer of the court, and it must list the things that they want to look through and the things that they wish to take from you. Now, there have been exceptions to this. That is true. Not a big fan of this. However, exigent circumstances, as defined in United States versus McConey, are circumstances that would cause a reasonable person to believe that entry or other relevant prompt action was necessary to prevent physical harm to the officers or other persons, the destruction of relevant evidence, the escape of a suspect, or some other consequence improperly frustrated legitimate law enforcement efforts. So, I'm not a really big fan of this. However, there is an exception as deemed by the Supreme Court as necessary, that they may not have a warrant if they see that exigent circumstances dictate that they need to enter your home or do some sort of action that would normally require a warrant. Not a huge fan of this. I don't like it when there's exceptions to these things that are laid out as decided by a court at its whims, but those are the rules that we're currently living under. We'll just have to figure it out going forward, and those can always be changed and overturned by a future Supreme Court as well. Look at Roe v. Wade. And then he finally come to the Fifth Amendment, the last one in the first half that we're going to discuss today, that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or an indictment of a grand jury, except in the cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be witnessed against himself or herself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So the Fifth Amendment provides several protections here for people accused of crimes. It states that serious criminal charges must be started by a grand jury. That process exists now for pretty much felonies and the like. A person cannot be tried twice for the same crime if they are found not guilty. That's our double jeopardy restrictions, or have private property taken without just compensation. This is the concept of eminent domain. The public can seize property if it sees fit that it's for the public good and it can be justified, but they must pay fair market value for whatever is taken. They can't just take it and say, it's for the public, too bad. No, they must compensate the owner. People have the right against self-incrimination and cannot be imprisoned without due process. So that's probably where you hear the most about pleading the Fifth in court television or in television in general. Now, this is just one of the protections of the Fifth Amendment, but you do not have to testify against yourself if it risks self-incrimination. However, there have also been exceptions to this. If you do make statements or if you do certain things, you can actually accidentally effectively eliminate your Fifth Amendment protections. So you must be very careful when interacting with the government. I would always recommend doing so only at the advice of an attorney, and do not overshare. You shouldn't share with them in general, especially without an attorney present, but definitely don't overshare. You're going to get yourself in a lot of trouble. So be smart. Don't self-incriminate. Don't talk to the government or law enforcement without an attorney present. Just don't. You don't know the law well enough. The law is way too complicated. Be safe. Stay quiet. It's the best advice I can give you. But for those of you who made it to the end of this video, I appreciate you watching. Next week, we'll be back with the second half of the Bill of Rights with Amendments 6 through 10. Go ahead and like the video, leave a comment below, share it with friends, family, neighbors, churchgoers, other random people in public, coworkers, whoever you wish. Share it. Share it as much as you can. Help me out. But thank you everyone for watching. Take care. Have a great rest of your week, and God bless. Go ahead and check out one of the links on the screen now to either subscribe to the channel and see the rest of the videos of the channel, or one of the carefully selected videos that you may wish to see that YouTube has used its algorithm to select for you.